Assalamualaikum and hi. My name is Harith Syahmi bin Muhammad Nur Azan. So today, me and my other group members will present the topic about common law and civil law approaches to sale of goods contracts. Allows me to introduce my group members. Me, Harith Syahmi bin Muhammad Nur Azan, and the other group members, which is Muhammad Afif, Aqwa Hazim, Danish Eiman, Muhammad Adli, and the last one is Ahmad Muzzammil. Okay, so let's cut the chase. For introduction, there are three characteristics that separate civil law from common law. The first is the relative significance of codification, which is claimed to be an element of national culture. The second is a general exposition of legal standards, with principle at the center of legislative formulation. The last one, the third, there is a lack of regard for court rulings as legal exposure. Codification is not limited to the civil law system. The next part is introduction of sale of goods. The law which applies in Malaysia and the United Kingdom is to be found in the Sale of Goods Act 1957 and the Sale of Goods Act 1979. Both of these measures deriving a common ancestry from the Act of 1893. In structure and content, the code and the acts are the product of the system. In spirit, there are similarities which may be drawn between the principle derived from the text and their application to commercial reality. The sequence of the comparison is based on the text of the Civil Code, as the priorities of this text and those of the two acts, which between themselves also differ in the precise ordering of certain definition and concept. Then, I will explain about the essential definition. The main features of a contract of sale are first laid forth in the Malaysian Civil Code. This is in contrast to the Organization of the United Kingdom Act, which is in the first section of the Act focused on defining the creation and ramification of such contract. Finally, my last part is I will present about what is sale. There are three definitions in French Civil Code, which is deliver and pay, a contract or deed, and identities of parties. The French Civil Code defines a sale as an arrangement in which one person is expected to deliver something and the other to pay for it. A contract or a deed can be used to make a sale, and they also need to identify the identities of parties. The legislative text places a premium on the notion of two distinct parties and the concept of an object to be transferred by purchase. This may appear simple, but it is not without complication, given the potential for conflicting rights of parties in the same things. So that will be all from me. I will pass to the next presenter.
For the identity of good, there are three laws that define them, which is French law, UK law, and also Malaysia law. For the first one, French law. French law has roots from Roman law. They classify the goods into two, which is movable and also immovable. The movable is more to like personal property or and also tangible and intangible goods, and immovable is more like to real estate goods. For UK law, all personal property is definition of good. However, the money and also item in use are not a good. For Malaysia, movable property, stock, even shares are a goods. However, money and actionable claims are not. As you can see, these three law has different definition on goods. Now, let's go to the other division of goods, which is specific and also uncertain. Specific is pretty much straightforward. Specific good is a good that are agreed upon and also specified at the dates of the contract is made. While uncertain good is a goods that are not specifically identified and also agreed upon at the time of the contract being made. I guess that's it. The other division of good will be existing goods and also future goods. Existing goods is the goods that are already present and physically exist in the seller's possession. while for the future goods, the goods are to be manufactured, produced, or acquired by the seller after making contract of sales, which means the contract comes first, then the goods comes later. Well, I guess that's it. Perfect and imperfect. Based on common law, there is no definite definition of perfect and imperfect contract. In fact, perfect and also imperfect contract depends on the fulfillment of the conditions for its creation or performance. Instead, according to the common law, circumstance might give rise to a party's right to a contract termination or an opportunity to excuse performance since the other party didn't complete the requirement. Agreement and acquisition of property. Based on French law, when sale occur between parties, which is two or more, it means that the property has been legally purchased. The term sale, it means that an agreement regarding the item and also the price, even though neither the price and also the item is not yet has been delivered or paid. For the acquisition of property, we can view this from two different sources, which is French law and also common law. For French law, the acquisition will only happen once the item and price has been agreed upon. However, the ownership will only be transferred when the payment has been done. And for the common law, the transfer of property is based on the nature of the goods and the party-specific agreement. The property transfers for common law is depend on the contract, actions of both party and also the environment. Agreement as to the thing and the price. For this subtopic, civil law and common law, both of it has pretty much the same approach to setting the price. Civil law and common law, both of it also emphasize more of the importance of the accurate identification and also the commodities in order for them to be covered by the contract.
Hi, I am Adli and I will explain about risks and conditions of sale and warranties. In both common law countries, risk moves with property. So until the buyer owns the goods, the seller is still responsible for making sure they don't get lost or destroyed. In the same way, the buyer is responsible when property is considered to have passed, even if no delivery has been made. In France, risk is handled by the general law of contracts. This says that the risk passes to the buyer when the property should pass to them, even if they haven't received yet. The seller cannot make the delivery. The risk stays with him. There is an exception when bulk goods have to be measured in some way, which means they have to be weighed or counted. It will be clear that the positions in all of the jurisdictions are very similar. Next, conditions of the sale and warranties. In France, a sale can be made without a conditions or with a suspensive or resolutory conditions that will end the contract and return the parties to their previous positions. Malaysia and UK sales contracts might be absolute or conditional. Both common law and the civil law systems know how to divide conditions into those that if they are not met, the contract is considered to be over, and those that if they are not met will result in damages. However, the two types which at the common law are called conditions and warranties, and in France are called the obligations of means and obligations of result, are not always the same. The parties may delay the transfer of ownership until the deed is notarized, but this not delay their obligations. But if the conditions is only good for the buyer, he can give up the benefit on his own and demand the seller to fulfill the contract right away. The buyer has the ability to waive any seller conditions in both common law jurisdictions. Buyer might also consider condition violation as a warranty breach to keep the contract alive.
Bismillahirrahmanirrahim. Assalamualaikum. My name is Danish Eiman bin Rozalizan, and I want to explain about effect of law and the position with respect to bulk goods. General principle of contract law in France govern how a contract of sales work in every case. In the UK, the common law and lex mercatoria apply unless they conflict with the Act. Despite the Act, bankruptcy laws applies any legislation not contradictory with the Act and bankruptcy law applies in Malaysia. The Contract Act 1950 applies unless contradictory with it. Even though the law in France is silent on the subject, it is true that sales of goods in insolvency situation are subject to a fairly detailed set of rules to figure out if a transfer of property has happened. Next, the position with respect to bulk goods. The sale is perfect if the merchandise was sold as a whole, even if it was not weighed, counted or measured. Although the price may be determined by measured, the sale of merchandise denoted by its location is a wholesale. Measuring only determines the final payment amount. In certain circumstances, such as wine, oil, and other items that need tasting before purchase, the consumer must sample and approve before buying. The 1995 Sales of Goods Amendment Act in the UK requires that the bulk is identified in the contract or by agreement between the parties and that the buyer has paid some money toward the price of the goods. This makes the buyer a co-owner of the bulk. The Malaysian Act does not include this restriction, yet they potentially elevate a major issue in bulk commodities shipping. Thank you.
Hi, my name is Muhammad Aqwa Hazim bin Ahmad Ghazi, and I will explain to you guys about the trial period. A sale in France that includes a trial period is considered to be a suspensive sale regardless of the length of the trial period. Once the precondition is met, the risk is transferred to the purchaser. So it is important to note that in both Malaysia and the United Kingdom, whether items are handed to the buyer on approval or sale or return, no property flows until the buyer indicates acceptance or does an act which implies adoption of the transaction. Next is sales and agreement to sale. France considers a promise to sell a sale if both parties agree on the item and price. After a unilateral pledge to sell, the recipient does not own the property unless the beneficiary has renounced the choice. The promisor cannot be released unless he gives notice to the beneficiary to accept within a specific time. So contracts are also classified into two types under common law. A contract to transfer property is known as a sale, and any agreement to sell that pretends to transfer future product in the present is referred to as a sale agreement. Agreements to sell become sales when requirements are completed or time pass. The next one is deposit and token of earnest. The issue of deposit is addressed in France by a statement in the code that states that even if the promise to sell is accompanied by a deposit, both parties are free to breach the promise subject to a penalty. This implies that the one who paid the deposit lost it, and if the other party decide to withdraw the commitment, the deposit is reimbursed twice. This provision applies to both sales and promises to sell. The situation in the United Kingdom and it is said Malaysia is dealt with common law and is determined by whether these payments are made in earnest and therefore forfeitable and as a partial payment, which may be recovered depending on which party is in violation. So the situation is exacerbated further by the fact that the magnitude of the cash may have an impact on whatever category of payment it falls under. Thus, a payment in excess of 1/3 of the purchase price was considered prima facie recoverable, set off against a claim for damage. The next one is the price. The price divided by two categories. The first one is determination by the parties. Determination by the party is France must negotiate the sales price, and the price is not set if the contracts only say the parties will agree on it. So if the contract stipulate that an expert will be hired if there is a dispute, the fee is decided. If the contract permits, the price is set by non-party factors. A contract without a price is invalid and cannot be verified or approved. And United Kingdom's and Malaysia's viewpoints are similar. Contracts can set or agree on prices, and it can also be determined by looking at past dealings. Unlike French law, which is where the price is not fixed, the buyer must pay a fair price, which depends on the fact, and its payment category. Thus, a payment over 1/3 of the purchase price was a prima facie recoverable but set off against a damages claim. So the next one is determination by a third party. So in France, the price might be arbitrated by a third party. There is no sale if the third party refuses or is unable to offer an estimate. So if there is an appointment clause and the parties cannot agree on who will be appointed, the courts may not appoint on their behalf. Although they may not be a sale if the price has not been established, the contract still exists in terms of the appointment clause, and the parties may claim for damages. So the agreement is avoided in Malaysia and the United Kingdom if the third party cannot or will not provide a valuation, but if any portion of the products has been delivered to the buyer, a fair price must be paid. And if the inability of the third party to provide a value is the fault of one of the contracting parties, the other party may seek damages. So the next one is cost of determination. In France, the cost of any deed and any other ancillary requirement that are necessary for the sale are the responsibility of the buyer. So in nations that follow the common law system, this question is typically resolved through the parties' collective agreement. And the last one is capacity to buy or sell. So in a brief section of the French Code Title 2, Chapter 2, anyone who is not prohibited can buy or sell. So the court has separate rules for the sale of property under tutorship, bailiff sale or public mandate, including a mandate by virtue of public office. This regulation ensure that property caretakers don't buy it. Selling litigation rights to judge is also unethical, and United Kingdom capacity is governed by property transfer and contract law, and Malaysia Contract Act 1950 Part 3 address capacity issues by referring to the parties' personal law.
Hello, my name is Ahmad Muzzammil bin Fauzi. I want to present about object of sale, what may be sold. So, in the French Code of Criminal Procedure, it is stated that unless banned by the law, French commerce may be sold. There are also some goods that are not considered as commerce, such as tombs, funeral concussions, professional clients, and the human body parts. Even with the approval of a live person, the inherited right cannot be sold. While in Malaysia and United Kingdom view, both countries have the similar views on on human body parts. In the Contract Act 1950 in Malaysia, they address that contract consideration and purpose. In UK common law, it determines what may be sold, and it is also excluded from the public order and morality. Next is nemo dat quod non habet, which means no one give what he does. So in Malaysia and United Kingdom perspective, the buyer gains no greater title than the claim seller in Malaysia and the UK, unless the owner has been prevented from contesting the seller authorization to sell. So let's say if the buyer sues the would-be seller for the cancellation and damage, the court may not award any kind of damage to the buyer if seller acts in a good faith. Last is perishing of goods, which we can divide it into two, into France view and Malaysia and United Kingdom view. So for the France view, it is stated that France nullifies sales if the item sold has fully expired. It is given by its nature or economic use. Partial perishing may cause a price change. So the goods that deteriorate and becomes useless are considered as null and void. In Malaysia and United Kingdom view, for Malaysia, perishing on a contract implies the item must have been expired before the buyer even accept the risk. Malaysia also defines perishing as a good damage to product that prevents them from fulfilling the contract description. Also, contracts are invalid if the vendor was unaware that item that is sold are expired. So, in the conclusion, the sale of goods legislation in France is covered along with other issues in one code, but in the United Kingdom and Malaysia, it is scattered along across many codes. In Malaysia, we need a solid case that may be made for clarifying the situation in Malaysia where two sales of goods law may coexist. So, common law and civil law may vary, but they still have some similarities. This is because it might be related to the Roman law and the necessity to solve the business issue. In the case, also we discuss about the contract parties' right, the responsibilities and liabilities. Civil law also show how different but similar with these two major legal families are. I think that's all from us. Thank you.